At the end of 2022, the Supreme Court once again took up affirmative action and heard two cases that threatened the decades-old precedent. With the decision expected sometime in June, it's a good time to reflect on the history of affirmative action and the cases that preceded the current ones. Most court observers believe that this court will finally strike down the precedent that has survived multiple challenges in the past. Today, we'll walk through a history of relevant cases, current arguments, and some clear research that suggests what will happen if the court strikes it down. This is a longer video than we normally do, but a shorter version of the podcast we recently dropped that you can find on your feed. And without further ado, UNFTR!
There are those who contend that it does not benefit African Americans to get them into the University of Texas where they do not do well, as opposed to having them go to a less advanced school, a slower track school where they do well. One of the briefs pointed out that most of the black scientists in this country don't come from schools like the University of Texas.
So this
they
court
come from lesser schools where they do not feel that they're being pushed ahead in classes that are too fast for them. I'm just not impressed by the fact that the University of Texas may have fewer. Maybe it ought to have fewer, and maybe some. When you take more, the number of blacks, really competent blacks, admitted to lesser schools turns out to be less, and I don't think it stands to reason that it's a good thing for the University of Texas to admit as many blacks as possible. I just don't.
No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. If civics class is a distant memory, that's the pertinent part of the 14th Amendment that guarantees equal protection for all U.S. citizens under the law. This amendment is at the center of the debate raging over affirmative action, a policy that allows organizations the discretion to determine policy, such as admission standards at colleges and universities based upon race, ethnicity, gender, and other qualified characteristics. The current cases, combined into one that was recently argued at the Supreme Court, might spell the end of affirmative action as we know it in this country. The clip you heard at the top of the show is deceased Supreme Court Judge and Supreme Racist Antonin Scalia questioning the attorney for the defendant in Fisher v. University of Texas at Austin. This was the second go-around for Fisher in front of the Supreme Court, one of the most notable cases against affirmative action. In 2008, a young woman in Texas named Abigail Fisher was denied admission to UT Austin based upon a formula derived by the university whereby the top 10% of graduates within Texas would be automatically accepted, and race, among other standards, would be considered for anyone outside of this tier. Fisher argued that on merit, she would have been admitted as she was just outside of the 10% and had a solid list of extracurricular activities and interests, and that she was excluded from attending because she was Caucasian. The university narrowly survived the appeal, even with Kagan on the sidelines due to a conflict of interest, because Scalia died before the decision was handed down. There are other cases that we'll cover, but the bottom line is that affirmative action has been the subject of debate for a long time. While the concept is mostly understood today in the context of university admissions, the phrase first appeared in the Wagner Act of 1935, which established the National Labor Relations Board. In the historical sense, affirmative action has been more of a preventive policy designed to root out discriminatory practices. In this sense, the term itself is kind of a misnomer and holds a different meaning than the concept the Supreme Court is designing, which is far more narrow. You have this standard of the 14th Amendment primarily created to extend rights to the formerly enslaved people in the United States, and hundreds of cases that rest on this logic either affirm or deny rights. In the case of anti-discrimination legislation or executive orders, most references to affirmative action are to affirm the anti-discriminatory nature intended by the 14th Amendment. So this is an important distinction because the word affirmative is positive in nature. It's affirming, deliberate, positive. Whereas anti-discrimination is inherently negative and defensive. It's do this versus don't do this. That strikes at the complicated nature of what this current case is all about. If universities were still denying people based upon race, gender, or ethnicity, it's a slam dunk don't do this because it violates the Equal Protection Clause of the 14th. But when a university actively admits or affirms the rights of a particular class over another, it's taking a positive or affirming action. Conservatives, and even some liberals, however, argue that the flip side of this affirmative action is necessarily the denial of someone else's rights, based upon the same logic. Your affirmation is my denial. The reason I'm being so specific about this point is because the precedent that has held together affirmative action by a thread is one that both sides originally felt they lost and won. And it all came down to the interpretation of the 14th Amendment, a justice that shocked everyone who knew the courts, and one of the lions of the legal profession who simultaneously saved affirmative action and planted the seeds for its eventual destruction.
Objective that impresses itself on my mind, partly because Dean Lowry testified it, partly because I am, at least in part, an educator, is the importance of including young men and women at both undergraduate colleges and the medical schools so that other younger boys and girls may see, yes, it is possible for a black to go to University of Minnesota or to go to Harvard or Yale. This is essential if we are ever going to give true equality in a factual sense to people, because the existence or non-existence of opportunities, surely we all know, shapes people's aspirations when they're very young.
Mr. Cox, what if Davis Medical School had decided that since the population of doctors among the minority population of doctors in California was so small, instead of setting aside 16 seats for minority doctors, they would set aside 50 seats until that balance were redressed and the minority population of doctors equaled that of the population as a whole? Would that be any more infirm than the program that Davis has?
Well, I think my answer is this. There is no reason to condemn a program because of the particular number chosen.
This is the thread that has held affirmative action together since 1978. It's the thread conservatives have been trying to cut and liberals have been hanging on to since this moment. In this brief exchange between famed attorney Archibald Cox, whom many consider to be one of the greatest presenters in history, and conservative Justice William Rehnquist, holds within both the basis for upholding affirmative action and its biggest weakness. Threading the needle in the end is an unlikely figure named Lewis Powell, whom we've covered before in rather unflattering terms. The beginning of Cox's statement to the court contains the logic upon which the liberal side of the court, with Powell as the deciding vote, sided with. The idea that it was necessary for white students to exist within a pluralistic structure to better prepare them for the real world and to demonstrate to other black Americans in particular that higher education in the United States is attainable. Both are arguments based upon modeling rather than correcting a historical wrong, which is the direction many liberals hoped the court would head. In this way, Cox understood a few things. The first was the composition of the court. In his research, Cox lined up the justices based upon their prior rulings and ideological leanings. In his estimation, the idea of righting a historical wrong was a losing proposition. Not that he didn't include this in his oral arguments, mind you, but he was cognizant that the conservative wing of the court wouldn't see this logic in a favorable light. This was after the Civil Rights Act, Voting Rights Act, and other decisions painstakingly won by people like Thurgood Marshall over the years. And it should be noted that Marshall was still on the bench for this decision. On the other hand, Rehnquist pursued an important line of questioning that derailed a complete victory for the liberal wing. The idea that the University of California had determined a hard number meant that it had created a quota of sorts. So Rehnquist pushes Cox to consider what might happen if they expanded the quota. In other words, is there a limit to the actions one could take in affirming the rights of minorities that would test the boundaries of equal protection? Alan Bakke was a competent engineer who honorably finished military service and decided he wanted to enter the field of medicine. He was twice rejected from the University of California Medical School at Davis and sued the university, claiming he was denied equal rights. The Bakke case took aim at Title VI of the Civil Rights Act of 1964, which forbids racial or ethnic preferences in programs supported by federal funds. What's fascinating about this case, among other things, is that the University of California was in favor of it going to court. Like many other colleges and universities, they sought clarity as much as Bakke sought a fair shake to pursue his dream. For his part, Bakke never once indicated personal feelings about the case and has never spoken publicly about it. He did indeed go on to attend medical school and enjoy a full career in the medical profession, by the way. Here's how the decision played out. The court first had to decide whether to pursue a narrow statutory framework or a broader constitutional one. The difference would have triggered a strict test of equal protection and the threat to a fundamental right, or a more moderate approach of heightened scrutiny, which allowed for some nuance. I'm not a constitutional scholar, so I'll leave the description there. Suffice to say, the less strict interpretation was pursued, which left wiggle room in the discussion for the surprise deciding vote cast by Lewis Powell. Recall in our coverage of the infamous Powell memo that Lewis Powell was a corporate lawyer and a shill for the corporate class generally, who implored the Chamber of Commerce to beat back the working class, liberal institutions of higher learning, and consumer advocates. He was rewarded by Nixon with a seat on the highest court of the land, despite never having argued a case in front of it. More importantly, in his prior life as the head of a school board, he fought fervently against integration. So appealing to Powell was a gamble on Cox's part, to say the least. What Powell objected to the most was the idea of quotas, which you heard in the second part of Rehnquist's question to Cox. He therefore ordered Bakke to be admitted to the university. However, he was swayed by the argument that a competitive process could take into account racial diversity in order to create a pluralistic environment, and that it was a college's right to strive for such conditions so long as a particular quota did not definitively foreclose on anyone's opportunity. As Emily Bazelon writes in a recent New York Times Magazine article, quote, "Though Cox had no way of knowing it, his diversity rationale would become the sole basis of affirmative action in constitutional law," end quote. Since the Bakke decision, the Supreme Court has repeatedly ruled that race-conscious admission policies are constitutional, including the 2003 case Grutter v. Bollinger. Just 6 years ago, the court rejected arguments against affirmative action and held that diversity is a, quote, compelling interest in Fisher v. University of Texas. Interestingly, it was conservative Justice Sandra Day O'Connor who wrote the majority opinion in Grutter. And while she agreed that affirmative action was constitutional, she suggested that race-conscious admissions should be temporary, citing higher grades and improved test scores for minority applicants. That was in contrast to the views of former Justice Thurgood Marshall, who during Bakke felt policies like this would continue, quote, for 100 years, according to Bazelon. But O'Connor wrote that, quote, all government use of face must have a logical endpoint. Well, today, it seems that conservative activists have found their endpoint. That the court seems ready to abolish affirmative action is partly the result of an activist base in the conservative movement that has been focused on this issue for decades, as were elements hostile towards Roe v. Wade. The aforementioned Fisher v. University of Texas case in 2015, along with the pair heard by the court last year, Students for Fair Admissions v. President and Fellows for Harvard and Students for Fair Admissions v. University of North Carolina, have been orchestrated by Edward Blum, a failed political candidate turned court activist. Blum, who isn't an attorney himself, is also the brainchild behind the court's eventual gutting of the Voting Rights Act. According to the New York Times, Blum is the puppet master behind 24 lawsuits related to affirmative action and voting rights in recent years. He's also the founder of Students for Fair Admissions, which received $7.7 million in contributions between 2016 and 2020, according to tax filings published by ProPublica. Additionally, the Times reported that an organization called Donors Trust, which helps fund conservative and libertarian efforts, gave nearly $2.9 million to support Blum's work between 2010 and 2015. In an article published a decade ago, Mother Jones described Donors Trust as, quote, the dark money ATM of the right, end quote. Unlike the current court, the justices who decided Bakke understood the concept of diversity given the extreme levels of racial discrimination that pervaded society at the time. And sure, things have improved for Black and brown Americans in the ensuing decades, but there still remain staggering levels of racial inequality, including in education, jobs, and wealth distribution. O'Connor in 1993 opened the door for a future court to rule that with discrimination purportedly on the decline, affirmative action and similar policies are effectively moot. Going back further, the diversity justification that appealed to Powell in 1979 seems to be the very thing that could seal the policy's fate in 2023. Obviously, the systemic issues that impacted minority communities for decades haven't been solved by affirmative action programs, and that's because centuries of mistreatment, discrimination, and outright racism are impossible to solve with a single policy prescription. But gutting affirmative action would leave thousands, if not millions, out of schools and programs that give them a chance to succeed. In 1996, California voters approved a referendum banning race in admissions decisions at public universities. In an amicus brief filed in support of Harvard and the University of North Carolina, lawyers for the University of California said the ban resulted in at least a 50% decrease in enrollment from students in, quote, underrepresented minority groups. The system has tried various efforts to improve diversity, which it still sees as part of its mission, including holistic admission policies, expensive outreach efforts, and other programs. Despite their best efforts, there's been a noticeable drop in diversity since the 1996 ban, which the university says has been particularly harmful to Black, Latino, and Native American students who say they report feeling racial isolation. The university also implemented a holistic review and eliminated the use of standardized tests. Despite everything, the system admitted that true progress remains elusive and that demographic data at its campuses compared to high school graduates in 2019 reveals stark disparities that undermine UC's ability to provide the educational benefits of diversity. In other words, it ain't really working. When white people think about affirmative action today, it's largely pejorative. That's unscientific, of course, just an anecdotal reflection of my experience. It's not necessary. It's outdated. Quotas are bad. You can only get ahead these days if you're some sort of minority. There's nothing racist about meritocracy. The playing field is level. After all, we even had a black president. White culture has turned the tables and adopted the posture of the aggrieved. Statistics and facts don't matter. The most serious questions in the current case have come from newcomer Ketanji Brown Jackson, who set a rhetorical trap regarding legacies. Pointing out that the status of legacy could be considered in the constellation of non-meritocratic factors for admission, she posed a hypothetical situation. Two kids, both fifth-generation North Carolinians, one white, who would be the fifth generation to attend UNC, one black, who would be the first to attend because prior generations were specifically excluded. Whose story is more compelling? The attorney's response was that it didn't have to be taken into consideration, and in saying so, fell directly into Jackson's trap. If legacy status didn't have to be considered, then it also meant that it could be. By the same logic, race shouldn't have to be considered either, but it also could be. In this one line of questioning, Jackson exposed the entire gambit. It was never about equal protection, clarifying statutory or constitutional rights, righting historical wrongs, or even declaring an end to the need for affirmative action. It's simply about taking away the ability for a university to consider all of these things to build a more pluralistic society that offers a chance to historically marginalized citizens. to claw back hard-fought rights and opportunities, because they don't want pluralism. They want whiteness. And that's what they're going to get. Here endeth the lesson.